This trial looks like it's about the facts. It's not. It's about power and what happens when the rules start getting in the way, because at one point, instead of simply following the structure and letting the evidence speak, everybody around this case starts running into the same problem. The facts are contested, the proof is incomplete, and the setup looks unstable. And the cameras could have settled the whole thing is not there. So the real question is not just whether Kelsey Fitzsimmons pointed a gun. The real question is what the system does when the one fact that matters most cannot be proven cleanly. And everybody still wants a decisive answer, because that is where the case starts becoming a near-perfect LSAT pattern. One disputed act, two competing accounts, serious institutional stakes, and a judge ultimately says, in substance, I'm not here to solve every grievance in the story. I'm here to decide whether the state proved one criminal charge beyond a reasonable doubt. And that is the first point people miss. This case didn't end with a sweeping declaration that one side was pure and the other side was corrupt. It ended with something narrower and in some ways more uncomfortable. The prosecution didn't prove its version far enough to convict. Now, to understand what that means, you have to start with the court dispute. On June 30, 2025, officers served an abuse prevention order at Fitzsimmons' home in North Andover. So during that encounter, she was shot in the chest by Officer Patrick Noonan. And from that moment on, the whole criminal case started narrowed into one brutal factual fight. The prosecution's position was that she pointed her service weapon at a fellow officer. The defense position was that she pointed it at herself, and that is the axis of the entire case, not 10 issues, not 50. One, where was that gun actually pointed? Because if it was pointed at him, the state has a viable assault case. If it was pointed at herself, then the theory the prosecution needs start collapsing. And what makes this such a strong talking head case is that everything else branches off that one disputed fact. Now, before that June 3rd encounter, there is a background. In pretrial filings summarized by the Massachusetts Supreme Judicial Court, Fitzsimmons' then fiancé alleged an intoxication and violence incident and then threatening statements that he said led himself to seek an abuse prevention order. And that matters as a procedural background. But that is an allegation in the pretrial record, not a trial finding on guilt in the assault case you're really analyzing here. That distinction matters because one of the easiest ways to ruin a case analysis is to blur background and an allegation into a proven trial fact. And that is exactly the kind of a slippage that makes commentary weak. If you want to sound sharp, you separate what was alleged from what was proved. And this case punishes anyone who doesn't. Then the criminal process begins to take a shape. On August 25, 2025, Fitzsimmons is indicted on one count of assault by means of a dangerous weapon. And there is a detail here that matters more than people realize. The earlier, more severe charge of armed assault with intent to murder was not indicted, according to the High Court summary. That means even before a trial, the case that survives is narrower than the most explosive version of the narrative. And that is your first timeline inconsistency block. Because when the public hears a dramatic story, the public often assumes the most aggressive legal theory survived intact, but here it didn't. The process itself already trimmed the case down. That doesn't prove innocence, but it does tell you the legal system was not blindly rubber stamping the most inflammatory version of events. Then comes one of the most quietly controversial parts of the entire story, pretrial release. At an August 28 dangerous hearing, a judge found Fitzsimmons dangerous, but still ordered to release under strict conditions: house arrest, and GPS monitoring, alcohol abstinence, a scramblers testing, and a treatment plan. And then the structure starts to break. Between September 8 and September 11, release state then began. And then Fitzsimmons seeks relief from a scram and as physically impossible due to her injuries. The judge vacates release and orders detention after concluding she cannot comply with the required conditions. And this is one of the strongest system design angles in the case, because once a court says, here are your least restrictive conditions, but those conditions are functionally impossible to satisfy, you have a serious question: is it really a release? Or is it detention wearing procedural makeup? That doesn't automatically make the courts wrong, but it does create a pressure point. If a condition is theoretically lawful and practically impossible, then the system starts looking more rigid than rational. And on September 22, 2025, the Massachusetts Supreme Judicial Court affirms denial of extraordinary relief. In other words, The High Court upholds a detention decision and finds no abuse of discretion. So the pretrial detention track survives appellate scrutiny. And that is important because it means later commentary cannot honestly pretend the entire pretrial process was casually overturned by a higher review. It wasn't. But this is where the reasoning style has to shift. The fact that a detention ruling survives review doesn't automatically answer the criminal trial question. And that is the mistake people constantly make. They treat pretrial rulings like a hidden proof of ultimate guilt. They are not. They answer different questions under different standards at the different phases. If you collapse those phases together, your analysis becomes loopy. And this case has too much internal tension for a sloopy analysis. Then we get to the strategic turns that made this case especially interesting. On March 19, 2026, Fitzsimmons waives a jury trial. This case is set for a bench trial before a judge, Jeffrey Karp. The prosecution also places on the record a past working relationship between the judge and defense counsel without objecting to Karp presiding. That is not a random procedural note, that is a strategic hinge. Because once the defendant chooses a bench trial in a high-heat case like this, the battlefield changes. Now, the fact finder is not 12 people trying to process a volatile emotional record. It's one judge trained to isolate a specific legal element that matters. That doesn't guarantee a win for a defense, but it absolutely changes the risk profile. And that is why the bench trial was a defense power move. That frame is strong. Not because you can prove the motive with certainty, but because choosing a judge over a jury in a case like this is a rational bet, and that a legal structure may matter more than emotional reaction. From March 23 through March 26, the bench trial unfolds. Opening statements, witness testimony, surveillance footage, and nobody cam footage. And a judge authorized visit to home and the closing arguments, and then verdict. And this is where the most viral frame comes in. This was the case that got decided by the cameras that wasn't there, because Judge Karp later says, in substance, that body cameras could have made the prosecution burden easy. But the department didn't have a body-worn camera at the time, so instead of one clean piece of objective evidence settling a central dispute, the court is left reconstructing the events through testimony, surveillance, mechanics, memory, and inference. And that is not a small evidentiary gap. That is a hole at the center of the whole case. And once you understand that, a lot of what happened later starts making sense, because people want a definitive answer. But the institution that could have captured the most decisive answer had not yet built the evidence stream into the encounter. So the burden does not get easier, it gets messier. And then the aftershock makes the point even harder. After acquittal, the town says it's actively working toward a body-worn camera program. And the police unions later vote no confidence in a chief, explicitly tying the body camera failure to the outcome and raising evidentiary integrity concerns. That's not SUP. That's a post-verdict institutional behavior that reads like a tacit admission that the missing evidence problem mattered. And now, a shift to the next major reasoning block. Two credible witnesses. So this is one of the most interesting parts of the verdict because it scrambles people's instincts. Judge Karp says in substance that he found both accounts largely credible. That sounds impossible to casual viewers because the assumption is if both accounts conflict, one witness must be lying. But that is not necessarily how credibility works in a criminal case. A judge can find both witnesses broadly insincere and still concede that the conflict on the critical element creates reasonable doubt. And that is where the LSAT-style pressure really starts. If the only disputed fact that matters is where the gun was pointed and the judge cannot resolve that dispute beyond reasonable doubt, the state loses. Not because the defense proved alternative story beyond a doubt, but because the prosecution carries the burden. And that is the part people hate when they want a clean moral ending. And that is also the part that makes the legal analysis real. So when people say, how can both witnesses be credible? The better answer is because credibility is not the same thing as conclusive proof. And under criminal burden, a tie on the decisive fact is structurally a loss for the state, not emotionally, structurally. Now comes the mechanics block. Because the prosecution didn't just rely on memory, it also relied on the firearm mechanics. The narrative depends in part on an empty chamber click and on tap rack or similar manipulation leading to a loaded round, multiple witnesses in traced weapon and just round issues and firearm sounds, and defense disputed intent and direction. That is why this case is such a good for a comment word generator. It's a physics problem disguised as a credibility problem, because once the prosecution says, essentially, the only way that gun got into the condition is through the specific manipulation. It's inviting the court to convert a mechanics inference into a proof of a human conduct. And it is not necessarily crazy, but it's vulnerable. Because the leap from the weapon ended up like this to therefore she did this for this reason in this direction, it's exactly the kind of inferential chain that gets stress tested under reasonable doubt, especially when a central fact is already disputed, especially when the body cam evidence that could have aligned mechanics with behavior that does not exist. And now watch what happens next. The case stops being about just physics, mechanics, and starts becoming about witnesses' posture. On cross-examination, officers known and concedes it's possible he called Fitzsimmons a whack job, and that the defense uses that to attack neutrality and attitude. And a separate reporting reflected a similar phrasing being raised around the testimony. And this matters for a simple reason. If you call someone a whack job, you have just made it much harder to sell yourself as a neutral observer whose reactions were perfectly dictated and clinical. It doesn't automatically destroy testimony, but it introduces a bias pressure. And the bias pressure matters most when the case already depends on whose account the court finds more credible. And this is where one side starts to look legally weak, because if the state's theory depends heavily on a witness interpretation, and the same witness is now forced to concede language that sounds dismissive, loaded, or openly derogatory, the prosecution is no longer standing on a pure fact. It's standing on a fact filtered through a human being whose neutrality is now under attack. That doesn't prove fabrication, but it does make the witness less frictionless. And in a case this tight, friction matters. Now at the scene view blog, Judge Karp authorizes a site visit and explains that his observation become part of evidence like a jury view. And that is a powerful detail because it shows the judge was not content to keep this case trapped into inside transcript language. He wanted to test spatial logic directly, line of sight, distances, angles, movement, and the physical reality of the encounter. And that is one of the strongest judge did what juries can't, angles in the case, because he literally walked the scene not to become a detective, but because the facts apparently just would not sit still on a paper. And that fits directly into the verdict framework. On March 26, 2026, Fitzsimmons is found not guilty. Judge Karp cites reasonable doubt, notes the lack of body-worn cameras, and emphasizes that he saw no evidence of conspiracy. And that last point matters because it narrows what the verdict is and what it's not. It's not the judge endorsing every accusation the defense floated. It's not the judge declaring a larger institutional plot. It's the judge saying, essentially, I do not have proof beyond reasonable doubt on a narrow criminal element I am required to decide, and I'm not going to pretend that unresolved suspicions are substitute for proof. That's why the reasonable doubt isn't a sympathy, it's structure. A frame is so strong because it resists the lazy reading. As the lazy reading is that acquittal means politics. The more precise reading is that acquittal means the burden did what it designed to do when a proof does not fully close. Now, there is another volatile frame in this story. Why did the restraining order service becomes such a tactical disaster? Defense and later civil counsel questioned why colleagues served the order and why the adversary was allowed in the home. But this is where you have to stay disciplined. Those are claims and questions raised around the setup and later civil positioning. Judge Karp specifically indicated that the legality of the restraining order service, custody issues, and other surrounding grievances were not the thing he was deciding in a criminal verdict. So the strongest way to use that angle is not to overclaim. It's to say the verdict was about one narrow charge, but the setup raises bigger question that the criminal verdict didn't resolve. There is also one highly viral but wiki source angle you should handle with caution. A tabloid outlet reported that a prosecution pointed the weapon and pulled the trigger during argument. If true, it's obviously viral. So if you use it, you frame it as unverified or not solidly confirmed in the stronger local reporting. Otherwise, you risk building heat on a factual plank that may not hold. Now, move to the aftermath, because this is where the case mutates from criminal verdict into an institutional story. On April 1st and 2nd, Fitzsimmons and defense attorney Timothy Bradle announced presentment letters as precursor to civil litigation, signaling civil rights and negligence claims and questioning how the restraining order was served and why certain choices were made. That means the criminal case ending in a not guilty and does not close the file, and that matters for your ending because it keeps the story alive. Then between April 3rd and April Rule 8, the town says it's actively working toward the body cameras, and the police unions vote no confidence in the chief, explicitly tying body camera failure to the outcome. And that's not small afterthought, that's institutional aftershock becoming visible. And this is where the opening line pays off. This trial looks like it's about the facts. It's not. And not only. It's about power, about structure, and about what happens when institutions wait until after a high-profile case to fix the evidentiary hole that made this case so unstable in the first place. Because if body cameras are suddenly being prioritized after acquittal and unions are openly connecting that absence to the outcome, then the system is telling you something, maybe not in one official confession, but through the behavior, through reaction, through what gets fixed once after the damage is done. So the criminal case ended on one word, not guilty. But the bigger question didn't get answered in that courtroom, because the judge made clear that some of the surrounding grievances were not his place to resolve. He resolved the narrow criminal question in front of him, and that leaves the audience with a real fault line. When do people sound credible? When the central fact is contested, and when the cameras that could have settled everything is missing, is a reasonable doubt justice working or justice breaking? That is the question this case leaves behind, and it's why the story didn't end with a verdict. It branches into civil claims, a policy change, leadership fallout, and a much larger argument about evidentiary integrity and accountability. So if you want to understand cases like this the right way, you don't just ask who won, you ask what the burden required, what the system failed to capture, what the judge actually decided, and which part of the story were left alive for the next fight. Because this case was never just a headline, it was a stress test of proof, of structure, and of what happens when institutions try to operate in a gray space and then act surprised when the gray space swallows the case. And that is the question I want you to answer in the comments. When the decisive camera isn't there and the burden still stays where it belongs, do you think the verdict shows the justice system working exactly as designed, or failing in the exact place where the evidence should have existed? And if you want more breakdowns like this, where we read the record, separate allegation from proof, and track where the logic actually breaks, subscribe. Because this case is not over. It has started turning in something bigger.